On that note, I think we're going to turn it over to Ben. And in fact, we're right on schedule. And he's going to talk about technological advancements and patent disputes and judgments.
Thanks, guys.
Thank you, David.
Thanks, David. Thanks, Earl. All right. Okay, that works. Thanks, everyone. My name is Ben Mak. I am a patent attorney at Ridout and Maybee. That's my name, Ben Mak. You can add me to LinkedIn. So I'm going to talk about technological advancement in the context of patents and patent innovation and patent infringement. The reason why we're talking about this is there's a lot more court-tested cases in terms of what would constitute an actual innovation or technological advancement. And why that's good is now we know that, okay, they filed and got a patent, but also what were the thought processes and what were the technical distinctions that allowed the innovator to successfully prove that they had an invention, something that was new and inventive. So there's some good cases here. The one we're going to be talking about is Bell versus Eurocopter. It was decided back in 2012, but it has gone through various appeals, and so is court tested. It's also a good example because it is a mechanical case. So a lot of these innovations can happen in high tech, can happen in life sciences, but in terms of exemplary cases, it's good to go back to the basics, which are the mechanics, and something a little more understandable. And if we want to go into the deeper cases based on subject matter field, we can obviously talk about those as well. But this is a great starting point that everyone can get on the same page. All right, so the international definition of an R&D project, as defined by the Frascati manual and as adopted by the actual entire SR&D regime, says that for a project to be classified as R&D, its completion must be dependent on a scientific and/or technological advance, which is what we're talking about today. The aim of the project must be systematic research, resolution of a scientific and/or technological uncertainty. Sorry, there's a bit of delay here. Okay, so as Dave mentioned, this is one way to visualize it. You start with the square, which is your standard practice, your knowledge base. In patent world, we call that the prior art. Next, you have your uncertainties. What problems were you trying to solve? And then you have your activities, which is the green circles. So all of this can result in technological advancement. All right, and from the International Tax Act, I'm just going to read this because it's not my expertise, but generally scientific research and experimental development thread means systematic investigation in field of science or technology. That is basic research for advancement of scientific knowledge. Without specific practical application in view, applied research for advancement of scientific knowledge with specific practical application in view, or experimental development for the purpose of achieving technological advancement for the purpose of creating new improved existing materials, devices, product, or processes, including incremental improvements there too. And that can include advancement to a computer sometimes. Whole point is we're talking about technological advancement here. All right, so your technical base or the starting point can include the technical knowledge of yourself, your personnel, any current products, techniques, and methodologies, including your own trade secrets and IP. But very importantly, it's publicly available sources. So it's not just yourself, it is what is known out there. Again, we call that prior art. You can call that baselining. But it can't be something that's found in a simple Google search. or even slightly deeper, which Google Scholar, Google Patents. All of these things are in publicly available sources. And that's the knowledge base that we're starting from. Okay, so I'll be talking about the patent case, which is Bell versus Eurocopter. So let's skip that. And there were a number, so it was in 2012 by the federal court. It was a patent case, and some of the side issues that came out also included this concept of sound prediction. And it was the first case that involved punitive damages. So that's very interesting. Normally, patent cases, we say whether it infringes and we count for damages or profits, but we usually don't look into too much about punitive damages. So this one did have punitive damages, mostly because the results didn't have a lot of damage. So the courts had to come up with something to compensate for the infringement. Okay, so if this was to be laid out as a thread case, let's look at this in a bubble for now. So let's say Bell, created a bunch of these things for helicopters. They're called landing gears. Landing gears is the feet of the helicopter, and the biggest thing is what happens when you try to land the helicopter on a ground. The ground may or may not be level, could be dirt, could be a hard surface. And what were the ways that you were able to improve this landing gear, or you can think of it as feet. And there were a number of criteria that were involved. So this is a summary, which we can go back to at the end. Right now, it's fairly wordy, but the main points is that the defendant created 2 landing gears. First one was called the legacy landing gear, which is under year 1, quarter 1. And later on, they created something called the production landing gear, which is on the top right. Exemplary is year 2, quarter 1. And the legacy one, the short of it was the legacy landing gear did infringe, but they did do a workaround later on called the production landing gear. That one did not infringe. And we'll get into these actual features, but I'll read them quickly, but we can actually, it's hard to visualize them without a picture. But some of the features there were transition zones. There was a double curvature of transition zones. There was something called an integrated front piece. And eventually it was something that was a mustache shape. And later on, there was a workaround where they did certain joints and connectors that eliminated some of these features. So this is a picture from the patent on the left, and the legacy gear that it did infringe is on the right. So generally, they were the same for various reasons, which we'll get into. But generally, if you think of a helicopter and the legs, generally there's a bunch of crossbars, and you have the feet on the bottom of the helicopter. And there are problems that arise from that. The biggest one being what they call ground resonance. So generally, you have a spinning top on the top of the helicopter. You're trying to land, and then as you interact with the ground, as we know from physics, is going to push back up into the helicopter, and you're going to get this thing called ground resonance. If you want to think of it as a simpler thing, we can call it just shocks, like a smoother way of landing, and the shape of it will help you land. So the front of the landing gear is a bit more smoother. We call it a double curve, and it will help smoothen when you try to land the helicopter. So this is what we would call a classic infringement and invalidity scenario, and it does look a bit like a mustache. Okay, so these are the 2 Bell products. The one on the right was the legacy, which is the one that infringed. It had this sort of, on the bottom left of that, a smoother front. And the one on the left is called the production landing gear, and that one did not infringe for various reasons, which we'll talk about. And these were the conclusions, which we'll get into. Okay, so This is actually a picture of a conventional landing gear. So you can't see the helicopter, but imagine there's a helicopter on top of it. And these are the feet of the helicopter. So generally, we're looking at a lot of right angles or rectilinear angles. We have the bottom, which is sort of a sleigh, and then the crossbars that run from left to right are more rectilinear. They're more like 90 degrees. So the patent was an improvement over that because, again, it was a little smoother and a little more able to land without the ground resonance. Okay, so we did have this little mustache thing. So basically, on the bottom left in the patent, the front of the landing gear, which is on the bottom left, kind of bends a little bit outwards and has a double curve, which I'll show later. So it's a little more smoother to land. In the patent, there was actually another picture where it was angled backwards. So on the bottom right, the front of it had this weird backwards angle. And as I'll discuss later, that one was actually thrown out because it actually didn't help. It made it a bit worse for numerous reasons. So that embodiment and the claims directed to that was actually found invalid because it didn't work. It was actually poorer than just doing a straight, more rectilinear 90-degree angles across. If you try to bend it backwards, it actually performed worse. So, I mean, in short, Claim 15 did cover the bottom left. Claim 16 covered the bottom right, and Claim 16 was thrown out eventually. And because Claims 1 and 14 were broad enough to cover both valid and invalid examples, those were also thrown out. But Claim 15 did hold up, which was a forward angle, a mustache-looking thing. And the helicopter had a sort of a forward bend, which meant that that was valid. And since it was just copied directly anyway, it was found to be infringed. Okay, sound prediction is sort of a patent concept, which is basically, does the patent do what you promised it to do? And we did sort of predict, or the inventor did predict, that it would perform better if we did have some sort of incline, but the results actually showed that the forward incline worked and the backwards incline did not work. There is a test for sound prediction, which is good for the patent world. So let's just skip that in the interest of time. Okay, so punitive damages. I mean, you have to look at the facts of the case, but this was just a straight out. They knew about it, they copied it, they infringed it, and the court was not very happy with that. So they did say that punitive damages were justified here. I mean, generally, it's hard to find punitive damages in patent cases. I mean, knowing about a patent is generally not enough. Knowing about a product is not enough. So, I mean, you have to be fairly egregious to justify punitive damages. It was more like that Bell was a sophisticated party, like they were larger and they were beating up on the smaller guy, things like that justified punitive damages in this case. And as I said before, for this legacy design, the one that copied, they really only made 12 of them. It was either 20 or 12. They never sold any. They kind of showed it around. So there was infringement, and the courts wanted to, again, somehow give the just rewards for the patent innovation, even though they couldn't actually find any damage or profits that were made out of here. So again, in law, that's not really a good reason to do that, but I think that's, you can see that that's what happened. All right, so the layout, this is actually taken out from the patent. It looks kind of like a mustache. The front is the bottom left, if you're wondering which side is the front. So we have, okay, so I mean, you have your claims, I have my claims. So I can't understand a patent unless I look at the claim. So this claim, it was actually a French patent, but the courts translated it into English. Generally, if all the elements in a claim are found in the infringing product, then it's infringed. And there are multiple claims. This is claim 1, and as I said, claim 15 held up. So in this case, we have the helicopter landing gear, which is the feet, comprising 2 skids, each having a longitudinal ground support surface and connected to a front piece and a rear cross piece, which are themselves attached to the structure of the helicopter by connecting devices. The rear cross piece, which is not that important to us, is attached by the ends by its descending branches to the rear part of said longitudinal support surfaces, characterized in that each of said skids has at the front an inclined transition zone with double curvature orienting itself transversely in relation to said longitudinal ground support surfaces above the plane. The 2 transition zones together constituting in this way an integrated front cross piece, offset in relation to the front delimitation of the plane of contact of the longitudinal support surface of the skids on the ground. So that's patent claim. That's what I do all the time. Hopefully they all don't read this badly. But there's a couple highlights. Basically, the front, it's integrated, in which we kind of in the patent world think of it as more one piece. So you would either mold or bend or cast the front piece. That's what integrated means. And then we've got these transition zones, which is the double curvature, so this is the prior art that I talked about before. Where's the thing? Okay, so this is the double curvature. Figure 10 is probably the best. So there's 2 curves. Got a little curve in C1, which is from the bottom of the feet to starting to get to the front crossbar, and the C2 goes from the crossbar and then from the upwards to the crossbar. And these are kind of curved. They're what we call double curvature or 2 transition zones. So this is the patent, and we see whether it's infringed. These are results from the patent. So the bottom right, the front is facing forward a little bit, and then based on testing and resonance and all that stuff, they found that and the deformity and what we call basically like shocks of your car. It performed very well, whereas more traditional sleigh type, or you call them ski tip type thing on the bottom left, did not perform as well. All right, so the mustache, they said, claim 15, which was bending forward, was good because it did have a good, it was inventive and not obvious to have this integrated front cross piece offset forward in relation to the front delimitation of the plane of contact and of the longitudinal support surfaces of the skids on the ground. And this is a picture of the infringing one from Bell Helicopter, and it was found to infringe. Okay, so about a few years later or afterwards, after they figured out that they were infringing, they created this new one called the Legacy. The Production. They called it the Production, which was a workaround. And basically, instead of doing an integrated thing, instead of doing a double curve, they just did connection joints. So they called these things just connecting devices. They also call them saddle joints. It's kind of like a T-shaped joint in this red rectangle here, which connected the bottom of the sleigh to the front crossbar. Interestingly enough, they said actually performed fairly well and fairly close. And a lot of the functional things were the same. I mean, it's for the same purpose. It did help with your ground resonance and shock absorption and all those things. But it wasn't covered by the claim. Like the claim, this isn't a double curvature. This is just connecting things together. Yeah. So the backwards one was thrown out, as mentioned. Okay. So hopefully that is somewhat clear. So there's some other takeaways that we can do with this. So, I mean, what if this case happened today? What would we do? So generally, if we said, okay, we invented some new helicopter landing gear, what would we do? Actually, the best thing to start is to do a search of the prior art. There's a number of resources out there. Google Patents is a great start, Google Scholar, that sort of thing. And your own industry would have some knowledge on what's new and happening. So we type in our keywords, landing gear, ground resonance, shock absorption, all that stuff. So, you know, if we did do this today, perhaps this paper would come up, published in around 2020, even though the patent was more than 8 years ago. If we did it now, then this would be sort of the baseline called Influence of Contact Points of Helicopter Skid Landing Gears on Ground Resonance Stability. So it sounds relevant at the very least. And how would we do that? And this publication has some nice drawings. So they tested the bottom left landing gear, which now that we're all experts in landing gears, you can see that's more of a traditional one. It's all right angles. It's just like a foot. And then, you know, we're gonna have some crossbar that goes along the helicopter. And the point here is that it's gonna absorb some of the shock, and it's going to help prevent some of the ground resonance. Yeah. And then, you know, you're going to have your results on ground. So it's funny when you land and you're going to have a spinning top. Things are going to happen, and then you can measure the angles and the effect of your helicopter when it touches the ground. There's something called Eigen Frequencies. So it's just another variable that can be measured. If you want to reduce these frequencies, then that's part of your spread claim. Okay. So in our case, in the publication, it was shown that for the modal reduction approach, a special attention has to be given to the landing gears, attachment to the fuselage. The selection of these master nodes is imperative for correct eigenfrequencies and bearing loads. So that's what the conclusion of that paper and the results that they came up with. Yeah, so you can read this later. This is just more results from that paper. But they didn't really talk about, you know, again, the mustache design and the double curvature. So there may be enough merit from our own invention that we could proceed further and claim the SRED credits. Future cases for discussion. So, I mean, the patent world, there's lots of cases happening at the federal court. There's lots of cases happening at the Supreme Court in the US. Both are very strong in terms of just diving deep into one technology, seeing what the prior art and the benchmark was at the time, and then how that inventor overcame what was the prior art. So this is a mechanical case. In the future, we can talk about pharma cases, life sciences, or we can talk about BASc, which is more of a software case. As we all know, artificial intelligence is hot these days. I've got ideas on patenting that. I'm sure you also have ideas on how to shred artificial intelligence. So, you know, I'm always happy to chat about these topics. They're always interesting because they're always new. It's new. They're always new and inventive technologies. Not sure. Is this the next case? Yeah. Sorry, this is the next speaker. So thank you. I will do the handover and thank you, everyone. Sure. I may email me. I'm on the websites, or I made a LinkedIn. I'm sure we can connect and talk offline.
Thank you very much, Ben. It was very interesting to see it from a slightly different perspective than we typically see these things. So enjoyed that quite a lot. Our next speaker is going to be Elizabeth Lance, and she's going to talk about two main cases, Indicel Industrial Control Limited and National R&D Inc. With that, Elizabeth, I turn it over to you. We're actually ahead of schedule, but we've got a few extra things that if we have time, we're going to cover at the end. So.
Okay, that's wonderful. Meetings that are going ahead of schedule. Just before we jump into mine, David, is there anything you wanted to add or draw our attention to?
No, I'll just reiterate that I like the case that Ben did, just that it's a nice overview to everyone on how something as simple as a landing gear could actually be so complicated and stuff like that. And then secondly, just to tell you that I'll transfer control over for you to take over the slides.